Welcome everyone to CBIA's HR Hotline Live. Today we'll be talking about cannabis in the workplace. I'm Diane Mokriski, an employment attorney here at CBIA. I'm joined by two partners from Carmody Torrance Sandak Hennessey, Vincent Farisello and Nick Zaino. Vincent and Nick both have extensive experience advising owners and managers on all things employment law, including strategies for managing your workplace in a state where recreational cannabis is legal, outside of work, of course. Hi, Nick. Hi, Vincent. So we're going to start out with some slides to give you all some background on the legal issues you should be aware of, but our primary goal is to answer as many live questions as we can. So please submit your questions through the Q&A, and we'll pause the slides every so often to address your questions. So Nick and Vincent, why don't you start with the first few slides?
We're so glad to be here with you, as we are every couple months with HR Hotline. So yeah, we're here to talk about cannabis in the workplace. It's an important, a challenging topic. You know, between the passage of medical marijuana law in 2012 and the recent passage of the recreational marijuana bill. And, you know, there seems to be some changing attitudes in society about marijuana, plus existing frameworks that have been in place for a long time. We're getting a lot of questions on this, and it's easy for employers out there to feel lost. Clearly, it's an evolving area, and so we recognized that there are lots of questions. And it also kind of requires employers, because one thing you'll see as we go through the materials and discuss this is employers still have a lot of latitude to decide to what extent they want to regulate, whether in or out of the workplace. And so it does require employers to kind of think about and examine how they feel about what their employers do regarding cannabis outside the workplace. So again, we're going to be here for an hour. We do have some slides to go over, but to your point, Diane, this is really about the questions, and so we strongly encourage those and hope that that's what drives the discussion. So just getting kind of right into it, there's a lot of statistics out there, but according to the CDC, use of marijuana is quite prevalent. It's estimated that in 2019, around 48.2 million Americans, or about 18% of the population, had used marijuana at least once. And that's likely going to only go up as more and more states like Connecticut legalize recreational marijuana. What's even more troubling about that is that probably around 30% of people who use marijuana have what's called marijuana use disorder, which is, you know, kind of having some kind of dependency or addiction to marijuana. And this is important because there are folks who use marijuana, there's some serious short-term effects. It alters senses, sense of time, it impairs bodily movement, impaired memory, thinking. And so it's no wonder that marijuana can have a significant impact on the workplace. It's also not surprising that according to one study, employees who tested positive for marijuana had 55% more industrial accidents at work, 85% more injuries, 75% greater absenteeism compared to those who test negative for marijuana. And you know, in the last few years during the pandemic, there are some studies out there that showed a significant increase in use just during the last few years. One study interviewed around 1,000 remote workers, 42% of whom suspected their coworkers or bosses were using during the workday, 15% of whom actually admitted that they used marijuana during the workday. So clearly there's the potential or actual impact of these laws on the workplace. And the landscape's really changed pretty significantly over the last 10 years, and it's going to continue to change. You can see here on this slide, the states highlighted in green are those in which recreational marijuana is legal. Those highlighted in blue are those in which medical marijuana only is legal. And you can see the blue and the greens are taking over. There are more of those than there are gray states. The gray states being those in which marijuana is still completely illegal. As for Connecticut, we were the 17th state to legalize medical marijuana. That was in 2012. And we became the 19th to legalize recreational marijuana in 2021. And if you look around Connecticut, the states around us, pretty much all of them have, some kind of legal marijuana system. Frankly, only New Hampshire, I think that's the only New England state that has not yet legalized it for recreational use. And then on top of all of these different state laws, what complicates things even more is the fact that marijuana continues to be illegal under federal law. And so there's still this, that's where a lot of the confusion comes in. So we thought as a good level setter, what we would do is just walk through, at least here in Connecticut, what the basics are. So I know my partner Nick now is going to chat a little bit about the medical marijuana law that's been in place for a little more than 10 years.
Yep, thank you, Vincent. So it is important for all employers to be familiar with Connecticut's medical marijuana law. It provides certain employment protections to those who qualify as either a qualifying patient or a caregiver of a qualifying patient. And so it's important for you to know who these folks are. A qualifying patient, to be a qualifying patient, they must be a resident of Connecticut and have been diagnosed with a debilitating condition. And there's an entire list and a growing list of what constitutes a debilitating condition on the Department of Consumer Protection website. But it's the conditions that you might expect somebody is using marijuana to be treated. So cancer, Crohn's, sickle cell, colitis, cystic fibrosis, muscular dystrophy, Tourette's, to name a few. It's quite a long list. Generally, the person has to be 18 years or older, but it is possible for somebody to be under 18 to be considered a qualifying patient as well if certain conditions are met. That person must have a written medical certification from either a physician, a physician's assistant, or an APRN, confirming that the person has a debilitating medical condition and that the use of marijuana would be beneficial in treating that medical condition and outweigh the risks. And then, of course, they must be registered with the Department of Consumer Protection, and there is a medical marijuana certificate that the individual would receive once they're registered with the Department of Consumer Protection. And so qualifying patients have certain protections, employment law protections, and so do caregivers. And so what is a caregiver, a qualified caregiver? Well, that is somebody who is caring for a qualifying patient. They're at least 18 years old, and they agree to undertake the responsibility for managing the well-being of the qualifying patient with respect to the palliative use of marijuana, and they cannot be convicted of a crime related to the illegal manufacture, sale, or distribution of a controlled substance. So if somebody is a qualifying patient or a caregiver, they're entitled to certain protections. What are those protections that they're entitled to? The statute goes on to say that unless required by federal law, and required is an important word, required by federal law or required to obtain federal funding, no employer may refuse to hire a person, may discharge, penalize, or threaten an employee solely because that person or the employee's status is a qualifying patient or a caregiver. And so you might be saying, well, we receive federal funding, or we are a federal contractor, or we must comply with the Federal Drug-Free Workplace Act. Does that create an exception for us? Do we have to hire somebody who uses medical marijuana? And the answer is no, that does not exempt you. Just because you receive federal funding, or just because you're a federal contractor, or just because you fall under the Federal Drug-Free Workplace Act, that does not automatically mean that you can refuse to hire somebody who is a qualifying patient or a caregiver. The Federal Drug-Free Workplace Act requires federal contractors to make good faith efforts to maintain a drug-free workplace, such as having a policy, having certain procedures in place, but it does not specifically require the employer to prohibit marijuana or hiring anybody who uses marijuana for a medical purpose. So that alone, federal funding and covered under the Federal Drug-Free Workplace Act, does not provide an exception. What are some valid exceptions? Well, the statute does say that an employer can refuse to hire and can discharge an employee, including a qualifying patient, if they're required to do so under federal law. So for example, if you hire CDL drivers, drivers who must carry a commercial driver's license, and they're governed by the federal DOT regulations, which federal law, as Vincent mentioned, prohibits marijuana. In that case, the person tests positive for marijuana, you can refuse to hire or terminate employment under the Connecticut statute. Same thing with certain pilots, bus drivers, train engineers, law enforcement, where there is a federal law that is applicable that forces your hand and requires you to take action.
I know where there's a few questions in
Sure.
the Q&A, two of which I'm going to just hold for now. We will get to them because I think we're going to get on that subject matter in just a few minutes. But the third one that came in is the caregiver a user of marijuana? And the answer to that, I believe, is no. This is just providing the user of the person who's a qualifying patient, that legal term of art. You listed all those requirements, is protected, but so is a caregiver who may not be a user, may not be a qualifying patient, but is just charged with caring for that person.
Yeah, I agree with that. So the question sometimes comes up, can a qualifying patient use marijuana at work for medicinal purposes? Is it okay for that individual to use marijuana pursuant to their doctor's orders at work? And so the Connecticut law says it does not restrict an employer's ability to discipline an employee who is either under the influence of marijuana, including for medical reasons, during work hours, and it doesn't restrict an employer's ability to prohibit the use of marijuana in the workplace. So you do not, as an employer, have to permit medical marijuana to be used in the workplace or allow somebody to be under the influence of marijuana. You also do not have to, there's another exception that says you don't have to allow the palliative use of marijuana when it endangers the health or well-being of a person other than the qualifying patient or the primary caregiver. So you might be thinking, well, that's a pretty good exception for employers. We think that this individual employee who, let's say they drive a forklift and they're applying for a job that requires them to drive a forklift, and they test positive for marijuana in your pre-employment hiring process. And you say, well, we think that's a safety position and it might endanger the health or well-being of others if you drive a forklift, right? I think you get into the situation here where that applicant says, no, but I have a doctor's note that says it will not. And I use this, at a particular time of day when by the next morning, I use it at night, and by the next morning, I'm not under the influence and is not an endangerment to, the health of anyone in the workplace. And so I think I would treat that exception narrowly and require that job applicant to provide a medical note if they use marijuana for medicinal purposes, confirming that in fact it does not endanger the health or well-being of a person. So I don't think I wouldn't take that exception and apply it broadly. In other words, I think I'd be very careful about applying that exception. So that's kind of like the entire, in a nutshell, the entire scope of the palliative use of marijuana statute. Obviously the next big statute that we're going to talk about is RERACA, which applies to those who aren't using marijuana for medical reasons, but rather are using it for recreational purposes.
Yeah, so you mentioned RERACA, that stands for the Responsible and Equitable Regulation of Adult Use Cannabis. That was the name of the law that was passed in 2021. What it did was it made, use, possession legal of recreational marijuana on July 1, 2021. It also had significant employment-related provisions that went effect a year after that, July 1, 2022. So if you're not already familiar with those provisions, it's important to become aware of them now, remain informed about them. Make sure you review, if you haven't already, your alcohol and drug policy. And as you do that, thinking about what position you as an employer want to take with respect to lawful use of marijuana outside of the workplace. Do you want to continue testing for marijuana? And as we go through the employment-related provisions, you can still do that. And you can still make decisions based on that. But if you choose to do so, you have to be aware of what your obligations are in order to do that. It also, at the end of the day, I think it kind of just requires employers to really examine if you want to treat marijuana differently or think about it differently than you do alcohol. Because if you think about it, most employers do not try or intend to regulate what folks drink, their employees use of alcohol outside of work, but except to the extent that that an employee comes to work impaired or intoxicated in some way. Certainly employers very regularly regulate what they do, regulate use or being under the influence of alcohol at work, but not outside of the workplace. So some employers are kind of re-examining whether to take that approach or not with regard to marijuana. Before we even get into the marijuana part of RERACA, one thing that kind of went under the radar quite a bit was a provision that regulated smoking in general in the workplace. This was called the Clean Air provision of RERACA. This went into effect, it's been in effect since October 1, 2021. And it essentially requires that employers ban smoking both inside the workplace, inside the facility, and also outside of the facility in an area within 25 feet of any operable door, window, or air intake system. And this restriction applies to tobacco, it applies to marijuana, not just actual smoking of marijuana or tobacco, but it also applies to nicotine or marijuana delivering e-cigarettes or vaporizer products. This is significant because before that law, employers of 5 or more were able to designate indoor smoking rooms. That's generally not okay anymore. And so this does require you to take a look, make sure you have this identified in your policy, in your employment handbook. But it also states that the person in control of the premises needs to post signage in a conspicuous place, alerting people that smoking is prohibited by state law. And there's some specifics about what that sign needs to look like, what size the letters are, and there are samples of that on the Connecticut Department of Public Health website. So just be aware of that. So talking about the employment-related provisions of RERACA. At the outset, nothing in RERACA stops an employer from prohibiting, nothing in RERACA stops any employer, no matter what size you are, whether you're exempt or non-exempt, and we'll talk about what that is, stops any employer from prohibiting employees from performing their duties under the influence of cannabis. All employers are still allowed to restrict possessing, using, consuming, or being under the influence at work of marijuana. The only exception to that is employers do need to allow a qualifying patient under the medical marijuana statute to possess their medical marijuana, but again, not required to allow them to use it or be under the influence. But aside from that small caveat, nothing in RERACA requires employers to allow people to have their recreational marijuana at work or to be under the influence of it at work. Aside from that, RERACA would then prevent employers generally from disciplining, terminating, or not hiring someone because of their lawful outside of work use of marijuana, unless that employer is exempt, and we'll talk about what that is, or unless, if the employer is not exempt, if the employer can still choose to do that, still choose to restrict employment of folks who use marijuana outside of work, provided they put together a policy. And we're going to get into the specifics of all of that. So starting with the exception for exempted employers. Exempt employers are not subject to the provisions, the employment-related provisions of RERACA. They can, without a policy in any event, continue to discipline employees, refuse to hire candidates who test positive at their discretion. That means exempt employers can regulate use in and out of the workplace as they see fit. The only exception to that is they can't terminate someone unless otherwise prohibited again by federal law, who's a qualifying patient under the medical marijuana statute. So who are exempt employers? Those are listed here on the statute. It includes, on the slide, and includes folks in the industries of utility, construction, manufacturing, healthcare, social services. How do you know if you fall into one of those categories? Depends on your NAICS code, that's North American Industry Classification System. For example, with regard to manufacturing, the law states that manufacturing includes all those NAICS codes under 31, 32, or 33. So to see if you're exempt, important to see what your NAICS code is. And we'll discuss this a little bit more later, but if an employer is not exempted from the law and the employer still wants to prohibit use outside of work, they can do so, but they would have to do so through a policy that's distributed to all current and prospective employees first. And we'll get to that in just a minute. So even if an employer is not exempt, so you could be a not exempt employer, some positions will also be exempt from the employment related provisions of the new law. That means a non-exempt employer can still be exempt from those employment related provisions with regard to exempt positions only. Not going to go through all of those, but they're listed here on the slide, but pointing out a few. If the position is funded by a federal grant, if the position provides supervision or care for children, medical patients, or vulnerable persons, that includes folks like daycare providers, nurses, CNAs. This is kind of one of the big categories, any position that has the potential to adversely impact the health and safety of others. And the interesting part about that is that determination can be made at the reasonable discretion of the employer. Also, certain construction positions are exempt, certain positions that require driving. So you could be a non-exempt employer, but still have exempt positions for which those rules do not apply.
So Vince, there's one question that may be relevant. There's one that may be the easy one. It's manufacturing company. They want to know if an employee violates their policy prohibiting the use of marijuana outside of work, can that employee be subject to disciplinary action, including termination of employment?
Yeah, assuming that the person is in one of the appropriate, and the employer is in one of the appropriate NAICS manufacturing codes, they're an exempt employer, and so they have the most discretion. Yes.
Right. As long as it's not used for medical marijuana, which we're assuming it's not. So
we know that exempt employers have wide latitude, and even non-exempt employers that have exempt positions with regard to those positions only. But what about the non-exempt employers? Well, I alluded to this before. They still also have quite a bit of latitude, as you'll see. And that's because, surprise, the law says that a non-exempt employer can still restrict outside of work use of recreational marijuana, provided that they implement a policy that does so. So a non-exempt employer can implement a policy that prohibits possession, use, consumption, even outside of work, as long as, you know, they don't take that action against a qualifying patient, and they abide by the rule to allow qualifying patients to at least possess, not be under the influence at work. But to implement one of those policies so that an employer can restrict that use outside of work, that policy needs to be in writing, and it can be done electronically, doesn't have to be on an actual piece of paper, but it needs to be provided to all employees before it's enacted, and it needs to be provided to all prospective employees at the time that the employer makes the conditional offer of employment. And so the non-exempt employer can also include in the policy that a positive drug test for marijuana on its own could result in an adverse employment action. So policy pointer, if you're a non-exempt employer out there thinking about what to do, and you do have decided that you do want to restrict outside of work, it's really important that you're very, very clear as you put together and implement your policy. You're very clear about what is and what isn't going to be allowed. All of this means that for a non-exempt employer, without a policy that states otherwise, Non-exempt employer without a policy would be unable to terminate or otherwise take adverse action against an employee or an applicant because they use marijuana outside of work. It means such a non-exempt employer would be unable to refuse to hire someone, for example, because they failed a drug test as part of the conditional offer of employment. So that's why if you want to do those things, it's really, really important to create and implement that kind of policy. Obviously, running through all of this are exceptions for even non-exempt employers who don't have a policy if hiring someone who's a user would make them lose a federal contract or their federal funding. All of this also means that without a policy stating otherwise, a non-exempt employer can't take action against an employee or an applicant solely because they tested positive for THC, the active ingredient in marijuana. And the reason for that is because that's not, the fact that someone tests positive for THC is not necessarily evidence of concurrent impairment or intoxication, because what we've learned is that that THC stays in someone's system for up to, in some cases, 30 days. So it's entirely possible someone tests positive because they, for example, smoked marijuana 2-3 weeks ago. Doesn't mean that they were under the influence at that time. So again, unless the non-exempt employer specifically states otherwise in their policy, the law would prohibit that non-exempt employer from taking action solely on the basis of a positive marijuana test.
Yeah, just one quick point, Vince. It's actually the most recent question. And I know a lot of the questions have come in about testing, and I'm going to turn to that next. Before we do, though, there's a question that came in. Manufacturers, so they're exempt, right, under RERACA. They want to know, what about their office employees? Are they also covered under the exemption? So once you're, go ahead, Vincent.
Yeah, the answer is yes. The employer is exempt.
Right.
The employer is exempt for all of their employees. And to just button that up, even when you look at the list of exempted positions, even that includes all positions that are employed by an exempt employer. So in two ways, all employees by the manufacturer are exempt.
Yeah. So let's turn to testing for a minute, because I know a bunch of the questions that come in relate to testing and what do you do when you suspect somebody's under the influence and so forth. And let's start with Connecticut's existing law on urinalysis drug testing. This is a law that's been in the books for a long time, decades, way before, the medical marijuana law and RERACA became effective. And that law regulates testing for urinalysis testing, both pre-employment and during employment. And the law says that pre-employment employers can do urinalysis drug testing, provided they inform the applicant in writing that test is conducted in accordance with Connecticut law, and really the lab that you use is going to ensure that that test, or should ensure that that test is done using the appropriate methodology under Connecticut law. You provide a copy of any positive drug test to the applicant, you maintain confidentiality, and you also not test that applicant during that during the last 12-month period. So that's pre-employment. You can't continue to test and test and test. What about, and you can also test for marijuana, right? And some of you have pointed out correctly that the big problem with marijuana testing is it doesn't pinpoint whether somebody is currently under the influence of marijuana. And so you may conduct a test for marijuana use and it turns up positive, but it does not mean that that individual is currently under the influence of marijuana, because marijuana stays in somebody's system for a much longer period of time than alcohol does. And so that is a serious limitation on the ability to take action on a positive test alone if you're taking action because you believe somebody's under the influence at work. And so we'll talk more about that in a minute, but you can still test for both marijuana and alcohol and all the other illegal drugs pre-employment, provided those conditions are met.
Yeah, one thing I failed to mention when I made the last point I made about for a non-exempt employer without a policy, the non-exempt employer would not be able to take action based solely on a positive test, unless, again, we have the federal exception, they're required to do so to keep federal funding or a contract, or in connection with that positive test, they reasonably suspect the employee used marijuana while working, or they reasonably determine that the employee had manifested symptoms. And I know you're going to talk a little bit about that in more detail in a few minutes, but the concurrent positive test with reasonable suspicion or a reasonable determination that someone's demonstrating articulable symptoms of impairment, that is still possible, even if they're a non-exempt employer.
Okay, so testing for current employees, urinalysis testing for current employees is limited. You don't just have the right automatically to test somebody on a random basis. You can only conduct drug testing if you have reasonable suspicion to believe that somebody is under the influence of drugs or alcohol. That is the general rule. Random testing is only permitted under very limited circumstances, and those are mentioned on the slide, authorized by federal law, designated as safety sensitive, and that is specifically designated as safety sensitive position by the Connecticut Department of Labor, meaning you need to contact the Connecticut DOL, and the DOL needs to certify that certain job classifications at your specific workplace are safety sensitive. And so that's an option if you want to conduct random urinalysis testing, or if that testing is being done pursuant to an EAP program in which the employee voluntarily participates. So those are the circumstances in which you can conduct drug testing during employment. There are no standards, at least published standards, as to what reasonable suspicion means. What does it mean that you reasonably believe somebody's under the influence of drugs or alcohol at work? There's just sort of common sense guidelines that I think employers should follow. You observe it, it appears based on their behavior, their speech, that they're under the influence. You smell alcohol, or you smell perhaps marijuana. Although no one thing alone is going to establish reasonable suspicion. It really is a combination of factors. They have slurred speech. They're acting in a way that shows that they're disoriented, or they're acting in an abusive manner. But again, not one thing is going to be dispositive. It's really a combination of factors that may allow you to have reasonable suspicion to conduct urinalysis drug testing at work. An accident alone in and of itself is not sufficient to constitute reasonable suspicion.
So Nick,
Yep.
you there for a second. You were talking about an employee smelling of marijuana, and that was actually one of our first questions.
Yeah.
Can you guys address that, how it applies to recreational marijuana and medical marijuana? If someone comes into work and they reek of marijuana, it may be that they smoked marijuana right before work. It may be that they were in a car with someone who was using marijuana. And so is the smelling of marijuana enough to discipline them on the one hand, or is it enough to test them on the other hand? Because those are two different things, right? Disciplining them versus testing them. Can you talk about that? If the only thing you can tell is that they smell like it.
Yeah, so what I would say is, remember, the law does not protect anybody who is using marijuana at work or who is under the influence of marijuana at work, right? Those are the protections that employers absolutely have, even for palliative use of marijuana. So, using or being under the influence. And we know that being under the influence is difficult to prove because there's not a test that can automatically prove that they're under the influence. So you got to rely on all these other factors to make that assessment. And there are factors, and that the statute lays out. Using is also very difficult to establish unless you see the person using marijuana, right? So I think the mere fact that somebody smells of marijuana would not be a basis to take any disciplinary action. And even if you have a policy or an exempted employer that says you can't use marijuana outside the workplace, right? Because again, like you said, Diane, somebody may reek of marijuana because they're around others who smoke marijuana, not that they necessarily used marijuana outside of the workplace. And so, on that one, what I would advise is having a conversation with that employee and saying, look, we smell a heavy odor of marijuana on you. Have you been smoking? Are you under the influence? Why do we smell this marijuana? And maybe allow that employee to give an explanation and give that person the benefit of the doubt, document that you had that conversation, perhaps ask that employee to go home, change, and then come back to work. And if it seems like that continues, in that pattern, there's additional instances, maybe that provides that basis to conclude that the person is under the influence of marijuana, perhaps. But the smelling alone would not be, in my mind, enough justification in and of itself to take disciplinary action against that employee, absent extenuating circumstances. Vince, do you have anything?
I was just going to say, I'm absent extenuating circumstances. I'm thinking of a situation where someone did not at all smell like it whatsoever during the first half of their shift, and then they go to their car or something to have lunch, and they come back, and then they do. That's also, though, different than if someone leaves or didn't smell, leaves work, goes wherever they go for lunch, and comes back smelling.
Right.
That may be less of a reason. But if they just went to their car and they didn't smell before, but they do now, that might be a situation where it does provide perhaps a reasonable suspicion.
Yeah,
no, I agree with that.
That was one of the, I don't know if you saw that, Vincent, but that was one of the specific questions. So if an employer suspects that somebody went out to their car during that lunch, and you suspect that they were using cannabis on the car, is that okay to discipline them? And they're a manufacturer, but I don't think that matters, right?
I don't think that matters either.
Right, I agree.
Okay, let's move on.
Yeah, I agree. So, as I said, employers can prohibit employees from working under the influence of marijuana, from using marijuana at work. And again, the testing for alcohol is easy. Urinalysis testing, the result establishes immediate impairment. It's just not true with marijuana because of the length of time that marijuana stays in the system. But RIRACA does allow an employer to take adverse action if they test positive or doesn't prevent an employer's right to take adverse action upon reasonable suspicion that they're using marijuana at work, or there's a good faith determination that the employee manifests a specific articulable symptoms of drug impairment at work. So those standards, I think those standards are important. And if I were an employer, I would encourage you to include that in your policy, that we reserve the right to take adverse action if we have reasonable suspicion of marijuana at work, or we have made a good faith determination that an employee manifests, and just use those exact words in your policy.
They come right from the statute.
Exactly. The next slide, again, I would put that in the policy as well that you have. And these are examples of things that may constitute specific articulable symptoms of marijuana use at work. And if you can establish that those symptoms are present, that those signs of marijuana use are present, RIRACA does allow you to take disciplinary action. Of course, you want to be careful and you want to be prudent in applying these standards, and but they're there, and they do give you a significant amount of latitude. And it doesn't mean a test, a test can't be helpful too. Like, you can require that employee to take a test, and if they test positive, that's another specific articulable symptom of marijuana use. So there are standards in that statute that I think give employers a fair amount of latitude. It would be good to train managers, and there are some vendors out there that provide training on what signs to look for if somebody's under the influence of either drugs or alcohol at work. It would be good that, if there are symptoms, it's documented what those symptoms are, that it's observed by at least two people in the workplace, so it doesn't look like one person is observing it. Maybe ask another person at your company to also see if they have the same assessment of that particular employee. Sometimes they do, sometimes they don't. Say, no, actually, I don't think they are under the influence. That, and sometimes they say, no, definitely. And so it's always helpful to have two people make that same assessment. And sometimes you don't have to take disciplinary action. You can just address it directly with that employee and say, look, it appears that you're under the influence. It appears that you're acting in a very disoriented manner, or you've got slurred speech. Is there something going on? Sometimes the employee will tell you it's the prescription medication they're taking. It's something that they, it's some other maybe protected characteristic or not protected characteristic. And sometimes you give them the benefit of the doubt on the first instance, but you'd still document that you had that conversation and continue to evaluate, how they're acting in the workplace. So I want to make sure before we go to the next, did we cover the questions about testing, all the Q&A questions on testing? The first one, employee uses medical marijuana on a regular basis. We've noticed a downward trend in their productivity. Do we ask the employee to get help outside of work, and can we write them up for decreased productivity? If this leads to termination, will they be denied unemployment? And so I guess what I would say is, if you've noticed a downward trend in their productivity, just address the productivity issue. I mean, I wouldn't even get into at all talking about they use marijuana on a regular basis, because the two may have absolutely nothing to do with each other. And what is clear is that their productivity has gone downward, and I would address that. And yes, you can write them up if their productivity continues to go down. And if they tell you it's related to something that might be a protected characteristic, that might be a different story. But you can still manage your employees and address performance issues. Would they be denied unemployment? Probably not, because somebody can be a poor performer and still collect unemployment benefits. So that would not be a reason for somebody to be denied unemployment benefits. Did we catch all the testing ones?
Yeah, I think so. We can talk
Okay.
maybe in a bit about ADA issues. There are a couple ADA questions.
Sounds good. So yep,
But I
that
think,
actually leads right into the next slide, unless you want to talk about it now.
Well, there's one question I think is appropriate for now, because it's kind of in line with what we've been talking about in the reasonable suspicion. 3 employees have told me, HR, that a couple employees are leaving for lunch to smoke in a nearby parking lot. Haven't seen any of the symptoms myself, so would that warrant any follow-up or possible disciplinary action? My feeling on that is you always have to be careful of rumor and innuendo, but this could be that there could be something there. The fact that there's 3 different people telling you, it does lead me to think, there's perhaps something to it. I wouldn't take disciplinary action just based on those reports. What I would probably do is do a little bit of follow-up, do a little bit of looking into it. If that's what folks are saying, make it your business to try to run into the people that are alleged to be smoking during work when they come back to the workplace. Go talk to them a few days in a row after they come back from work and see if you do notice anything that gives you any reasonable suspicion, or if they're demonstrating any symptoms of impairment. But, I don't think it's, being told that in and of itself necessarily, allows for or justifies taking disciplinary action, but certainly justifies you looking into it a little bit more.
Yeah, I totally agree. I would. In fact, I would just confront the employees either.
Just ask them straight up.
Yeah, just ask them, exactly. Because you have a duty to provide a safe workplace too. And I don't know what what the employee does in your specific workplace, but if they're in any kind of position where them being under the influence of marijuana at work could pose a safety issue, and you were made aware of this and didn't take action, that could be a potential liability as well. So I would follow up, but I agree, in and of itself, it's not a reason to take any disciplinary action. So, I know we have a question about sort of ADA issues, and I think it leads right into the very next slide. Can you terminate an employee for being an alcohol or substance abuser? And very specifically, the answer to that question is no. Both, addiction, substance abuse disorders are protected as disabilities under the ADA. So the fact that they are addicted to any sort of substance, or alcohol is not a reason in and of itself to take any disciplinary action against an employee. That's protected. However, the ADA nor Connecticut law protects an individual who currently engages in the illegal use of drugs or alcohol. And so that, if somebody does test positive for drugs, and I'm not talking just about marijuana, but any other illegal drugs or alcohol while they're at work, the fact that they may have an addiction does not protect that employee from current illegal use of drugs or alcohol. So you can continue to hold every individual accountable for the same performance and conduct standards. And I'm sort of oversimplifying that a little bit. There are situations where it gets a little muddy, but the general rule is if somebody's a current alcohol or drug user and they're under the influence of work, that is not protected.
Nor is the behavior that they do that may be a result of, like, an example I sometimes use in the context of someone who may have alcoholism or struggle with alcoholism. The fact that they are an alcoholic or recovered alcoholic in and of itself is protected. But what's not protected is they showing up to work drunk, or under or intoxicated, or because they're constantly late because they're hungover, or etc. So just differentiate the condition versus, like you said, Nick, the performance and conduct standards.
Yeah, there's some other questions here. We're a construction company. We're thinking of omitting marijuana from our pre-employment drug test. Should we? You know, I think many employers, it really depends on your, you know, your personal assessment of your workplace and what's important for you. And some employers have taken the position that they're dropping marijuana from pre-employment testing. They've just made the decision that, look, it's, you know, it's legal in Connecticut, it's legal in nearly all of the surrounding states, you know, around Connecticut, and we're just not going to test for it anymore. Like that, you know, if somebody chooses to do that outside of work, we're going to treat that like alcohol, and we're not going to require that as part of our pre-employment testing. There are other employers who, you know, they view their workplace as having many safety sensitive type positions, and they feel very strongly that no, we will continue to test for marijuana. It's illegal under federal law, and we want to provide the absolute safest work environment for our employees and ensure that the products that we manufacture or the work that we do is done, you know, with employees fully alert and not impaired at all by anything, whether it's drugs or alcohol. So they continue to test, and the law really allows you to have that latitude. So as a construction company, you know, you have to evaluate where you land on that. I mean, you've probably got, you know, assuming you've probably got folks that are operating equipment that they need to be fully alert and not impaired. And so maybe you err more on the side of caution and continue to test for marijuana. But, you know, that's a personal assessment that you have to make, you know, for each individual workplace.
Another question that I saw, it's about sort of what we were just talking about a few minutes ago. So the question is, so if you investigate and find reasonable suspicion, do you have to have them tested before terminating? And the answer is no. RERACA specifically does not require a positive drug test. It does allow for an employer to take adverse action if the employer has reasonable suspicion that the person used at work, or that makes that good faith determination that someone was under the influence at work. Certainly, you know, those two things could also justify doing a test under the urinalysis testing rules, and that could further bolster the argument, but it's not required.
So a couple of other good questions on the heels of that, Vince. One is, would seeking care to treat substance abuse qualify for FMLA job protection? The answer to that is yes. You know, treatment for an addiction, any addiction, whether it's any addiction, would qualify for FMLA job protection. It would likely be a serious health condition. The question after that, would annual reasonable suspicion training provided to our supervisors or managers hold any protections should someone sue for wrongful termination if they were terminated due to a belief they were impaired while working, given there is no conclusive test for impairment? And so it is helpful, but it is not a blanket protection against, you know, an employer who really doesn't have reasonable suspicion. In other words, it is definitely helpful if your supervisors are trained, but at the end of the day, they need to be able to identify specific articulable things that demonstrate that the person is under the influence of alcohol or drugs at work. The training in and of itself does not just give you carte blanche. Like it's helpful, but it is not just carte blanche to just do testing.
Another interesting construction related one. The question is, isn't anyone subject to OSHA safety training prohibited from using recreational cannabis per the exempted positions? No, not so. When we say exempted positions, that just means an employer who has employees who are required to do OSHA construction training. Those positions are exempt from the employment provisions of RERACA. That just means the employer of those positions can terminate them based on their use outside of work, or refuse to hire them based on a positive test. with or without a policy. That's all it means. It doesn't mean that the employer is obligated to take action against someone just because they happen to be someone who has to do OSHA prescription.
Mm-hmm. Yeah, the next question under that is, if you do not test for marijuana prior to hiring an employee, can they still be terminated for failing a drug test if it is from reasonable suspicion? And the answer is yes. I mean, the answer, you don't have to. The two are not tethered together. Like you may decide as an employer, look, we're not going to do pre-employment testing. We don't think it's all that helpful because it's just one snapshot in time, right? Somebody could be using marijuana regularly, but they're applying for a job, and so they stop using for 60 days, and then they test clean, but then they start using again. And so we are not going to test pre-employment, but we will test if we have reasonable suspicion to believe somebody's under the influence, and you do, and you meet that standard. They test positive, and you choose to terminate their employment. I don't see a problem with that, even though you don't test on pre-employment. So the two are not. It's not required that you do both. So I do think going back to a question that somebody raised, I think at the outset, should employers continue to do this? We are finding that an increasing number of employers are dropping it from their testing. And, it'd be great. I would love to know what many of you do, or if you've adopted any sort of policies that are different in light of the fact that marijuana is now legal. And if you just drop in the Q&A or in the chat, what your policy, how you've revised it, I think that might be helpful for the entire group. For violations of RERACA, there is a private cause of action, that employees can bring. So you do want to be careful about making sure that you follow the requirements, that the remedies can be reinstatement, they can be back wages, reasonable attorney's fees and costs. So there's significant penalties or damages, I should say, for violating the RERACA statute. And same is true with the palliative use of marijuana statute as well. Have we hit all the questions? Are there any other questions that folks have?
I think you've covered everything. Just the only one that's remaining, just so we're clear, you did cover this, but do you want to just answer James Ross's question? If an employer thinks that someone is impaired at work, do they have to offer, I'm assuming that's an ADA question, do they have to offer treatment?
No, the answer to that is no. You do not have to offer treatment or rehabilitation. If somebody is impaired at work, they're subject to disciplinary action. So whatever would be appropriate disciplinary action is what you can do. So let's assume that you decide you get a written warning or a suspension, or, and then the employee comes forward and says, I'm entering into, a drug treatment program. At that point, it would then convert to an FMLA leave.
Mm-hmm.
Right? Vince, do you agree with that, or is there anything more?
No, I think that's.
Yep.
I'm with you.
How do
All
we?
right.
Yeah, go ahead.
I was just gonna read that next one. How do we add recreational cannabis to our personnel policy alongside alcohol and other drugs? I mean, that their suggestion is actually yes.
Yeah, yes. It's got to be addressed somehow. And you can't rely on anymore on the catch-all of illegal drugs because it's not necessarily illegal. So I've seen it done a few different ways. Sometimes saying cannabis products with a parenthetical that says something like including without limitation marijuana or other products that contain THC. There's a few different ways of doing it. But it is important to be thoughtful about it and to be careful not to just rely on that catch-all phrase of illegal drugs. And then you also have to have, most employers do have to, also have some exception there for, you have to be careful about just saying possession of marijuana at work is strictly prohibited, because remember, there's the provision in the statute that does allow for qualifying patients under the medical marijuana law to possess at work, not necessarily be under the influence or use at work. So we generally try to cover that in a policy as well.
So Vincent, talking about policies, do you want to answer that one and that second one? If our handbook doesn't state anything about a drug test, can we still perform one. Interestingly, the writer says randomly with reasonable suspicion, and those are two different legal concepts. But if your handbook doesn't say you're going to do a drug test, can you still do one?
Well, this is a manufacturer, so at least under RERACA, they can do whatever they want with or without a policy. The real question is that allowable to do under the urinalysis testing rules? And while it's a great idea to, and I would strongly suggest having it in the policy, saying that you reserve the right to do that in the policy. I'm not sure that the urinalysis statutes actually say thou must have a policy in order to be able to do it for reasonable suspicion.
I agree.
Yeah, and this next question about providing transportation home, I actually just had that question a few days ago that had to do with whether an employer, aside from providing transportation home, does the employer have to pay for the time it takes to get the drug test? Is that considered wages? And the Labor Department's position on that was, yes, you do, because the employer is the one who wanted the employee to have the test. And so the employer pays for the time it takes to get the test done. And what do you think about the transportation home?
I think it's a really good idea to do that, or to require someone to pick them up, or to call them an Uber or a taxi or whatever, because I'd be afraid of sending someone home, watching them drive, and then they get into some kind of accident, hurt themselves or someone else while we suspected that they were under the influence. So I would very strongly recommend that you try to make sure they have a ride, or at least provide them some way home.
And it looks like we just have that one more.
One last piece on that. I have had the situation where an individual absolutely refused to take the taxi, the Uber, or a ride, and got in their car anyway and left. And I advised the employer in that situation to contact the local police and let them know what the suspicion was, and that there, because this is at that point it's a matter of safety. And if you have knowledge or the belief that someone's a safety risk to others, I would suggest letting the authorities know.
Yeah.
I see this last question. I think it was referring to something I said. Did I say that you cannot discipline if they are carrying cannabis at work, not using? I was referring to the term of art qualifying patient. That's a legal term of art. It's under the medical marijuana laws, as Nick pointed out earlier. That's someone who has a covered medical condition for which they have gotten a legal prescription for medical marijuana from a licensed, from an appropriately licensed physician or other healthcare professional, and who has a license from the state. We're only talking about that very narrow subset of the population. They are allowed to have it on them at work, only them, not anyone else. But again, they're not necessarily allowed to or permitted to use or be under the influence at work. We're not talking about a non-qualifying patient or a recreational marijuana possessor or user.
Okay. So I think we got to every question. That's great. Vincent and Nick, thank you so much for joining us, as always. I thought that was great. And if any of you out there have any other questions, please contact Vincent and Nick. The slides and the whole webinar as a whole will be sent to everyone in about a week. And you can email Vincent and Nick directly. Just Google Carmody Torrance Sandak Hennessey, and you'll see these guys if you have other questions. And for CBIA members, you can always call me as well. The number's right behind me. And we'll see you next time. Thanks, everyone.
Thanks, Diane. Thanks, everyone.
Bye.
Bye-bye.